Hey guys, it's Shawn. Welcome to today's video on what happens when you break a contract. Lawyers might use the fancy word and call this a breach of contract. But long story short, legal consequences flow when parties don't complete a contract, or at least potential legal consequences flow. Sometimes, if you're very lucky, you can break a contract. Maybe the other person doesn't feel like suing you. You get away with it. Or maybe they see that there's claims going both directions and they don't want to get the waters muddied, and you just get a free pass to break the contract. But a lot of times when you break a contract, the legal consequences hit, problems ensue. You could end up in a court case, and then you really need to look at what your potential exposure is and what the issues are. Today, we're going to give you that general overview of what could happen if you break the contract, what could go wrong, what a court might look at, and how we might start to look at what things are in place to remedy the situation, which you might be potentially liable for if you are indeed the one that breaks the contract. Now, a lot of this is, as always, state law specific, and states on contracts are somewhat uniform, but there are different holdings and different opinions and different situations. All of this playing to the fact you need to get your own legal advice for your specific situation. This is education. This will get you up to speed, give you a better idea of what you're talking about when you go in to talk to your lawyer, but it'll give you terms, it'll give you ideas. You'll be a better client. It's probably save some money on legal fees, but you really need to get that advice that's tailored to you. And the first question of the hour is, are you liable for breaking the contract? And that seems like a simple question, but a lot of times cases look at, who was the first to do a material breach? If the other person breaks the contract first in a major way, you may be in a situation where then you can break the contract, right? Courts are not so heavy-handed to say that you need to keep going if the other person has really blown the deal. So if the other person, repeatedly refuses to show up to perform work that they're supposed to perform, you don't necessarily have to keep paying them maybe the quarterly installments you had agreed to, right? The contract's just broken at that point. So you need to determine whether you're liable. Now, if everything's going well, everybody's doing their job, and you suddenly just stop doing your end of the bargain, you're probably moving to a clearer case where you are liable, right? You're at fault because you didn't do your end of the deal. Now, in the real world, there's shades of gray everywhere in the middle. No contract is performed 100% perfectly because we just live in real life. There will be minor defects, minor delays, other issues will come up, right? We cannot expect perfect adherence to a contract. We can get near perfect, and there are some companies out there that do fantastic work. But in the real world, we are generally in that gray area. You can probably point to minor things, problems, issues. The question is, are they material, right? A lot of times the court looks at the materiality of the breach. Is it an important thing, or is it a small thing? Is it important or not? So you need to look at that. First threshold is, are you even going to be liable? And a good lawyer who's been through a lot of contract disputes can kind of help you do that analysis of whether the situation is such that you're going to be held responsible for breaking the contract. The next thing we're going to do, and you've probably heard me talk about this if you've been around the channel for a while, maybe seen my video on LLC agreements and even corporations, I say go back and look at what the documents say. What are the terms? So we need to go back and look at the terms of the contract. And now we're looking for some very specific provisions. There's usually provisions in there on the breach of contract. What happens in the event of breach? Is there a cure period? Can one party have time to fix their potential breach after a notice usually? Is there a provision that sets forth what happens in the event of a breach of contract? Sometimes we'll see a provision that talks about a payment of a certain amount of money if the contract's not completed. It may have either an exact dollar amount or a formula in there. Now, those usually get put into two big buckets. One is what they call a liquidated damages provision. That's where it's a reasonably foreseeable estimate of what it might cost to remedy the situation in the future. That is, often enforceable. It can be upheld. The other type of provision is a penalty or a fine. Those generally are frowned upon by the courts. The courts don't mind people, anticipating what the damages are, trying to simplify things. avoiding that complicated phase where everybody's trying to figure out how much the breaking of the contract costs, what that breach costs, and what are the damages. So you could potentially do a liquidated damages, but you can't do like a massive fine or a penalty for that. So you want to go look at that terms. You may also have attorney's fees provisions that kick in. In Texas, in many cases, there are automatic attorney's fees for breach of contract actions. That's somewhat unusual. A lot of the other states don't necessarily have that, but a lot of people do put that in the contract. Essentially, that the person that breaks the contract is not only going to pay their attorney's fees, but they're going to pay the attorney's fees of the person that's going to come after them, right? So as fault is determined, the contract may have a fee shifting provision that shifts those fees from one party to another. So that is a real risk. If you're in a contract and you have a fee shifting provision, who's going to be responsible to whom, and is it going to not only be the damages, what the person lost, and we'll talk about damages in a minute. So not only will be that amount of damages, but is there going to be attorney's fees piled on top of it, right? That can now start to get into some very high stakes, risky poker on who broke the contract first, who's at fault. One form of compensation or damages we see is what they call money damages. This is probably the most common remedy for a contract break. The court will go in there and essentially do an assessment of what the losses are. And so the non-breaching party, the party who did nothing wrong, the one who was doing the contract and got, the other party stepped away from the deal and didn't do their part, they are usually entitled to money damages. And they're usually compensatory damages to put the person back into place as if the other person had performed the contract. So what you're going to do is look at where you expect it to be. What would have happened if the other person did the contract? When would your office building have been complete? When could you have occupied it? What could you have done in your office building? Right, and you can see, in that very simple scenario I pointed out, right, a broken contract to finish the building of an office building, you have a lot of uncertainty, right? How did it impact the completion? When would it have been completed? What would the losses have been as far as occupancy? What were expected profits from the business, right? You see a lot of speculation there. But that is one form of compensation, is you just, compute an amount and have a check go from one party to another. Courts often prefer that because it's clean and neat. Another possible remedy is specific performance. You get a court to order that the contract is going to happen as written. Now, this is a little more challenging, and courts are often a little more reluctant to do this because you're actually forcing somebody to do something, which you can see there are inherent issues with that. Right? If somebody didn't do the contract the first time, they may be compelled with a court order to finish it up when the court says so, or they might not be. You're generally not going to want to use this like in a construction contract. Somebody got halfway through completing your pool, they disappeared, now you need your pool finished. What you're probably going to do is hire another pool company and go for money damages. But a theoretical remedy would be to get specific performance. Now, for those of you who've been tracking the Twitter case with Elon Musk, as of the time of recording, there is a lawsuit going on between Twitter and Elon Musk, and one thing Twitter's asking for is specific performance. You said you're going to buy this company. You said you're going to pay whatever amount you're going to pay. Now we want you to pay that amount. We want you to finish buying the company. That is a specific performance demand. That is a possible remedy, although usually it would go the other way. If Elon Musk was trying to get Twitter to finish the deal, he would come in and say how unique and unusual Twitter is and how money damages would not be sufficient, right? Just giving me a pile of money and not giving me Twitter doesn't allow me to do the things I wanted to do with Twitter. Whereas Twitter is going to argue, we can't go out and resell this company. You've put us in a bad position. That's why they want specific performance. You might also see specific performance in the real estate context. Houses are unique, right? And, some are cookie cutters and some aren't. And so if you have a deal for a specific house and you want that specific house and the seller is not willing to perform, depending on your state, depending on your jurisdiction, depending on the facts, you might want to try for specific performance. I'll give you the money I told you I'd give you. You give me the house. I want the house. Again, you got to get court to go over that bridge. They are often reluctant to do it, but it is a very possible remedy. All of this points to the question of why are you breaching? You're probably not breaching just to be a mean person. There's probably some reason why you're breaching. You're not happy with the other person, circumstance just changed, you potentially found a better deal. There is a concept in the law called efficient breach, which is sometimes it is economically efficient to break a contract with one person, pay them their damages, pay them what they lost, and move on to another person and do a different deal, right? Maybe you have a limited amount of time and staff and you've got a much better offer. You can pay the smaller deal off, compensate them for their losses, and then make more money on the bigger deal. I would prefer people to do that through a negotiation, right? If at all possible, it would probably be better to do that on an upfront basis, to approach the person you have the contract with, buy your way out of the contract, negotiate a termination of the contract, and then move on to the other deal. Because if you don't tie up those loose ends, you could really end up in some nasty litigation with some uncertain damage calculations. So efficient breach could make sense, but you really need to know what you're getting into. You need to understand that risk profile in your jurisdiction. And you also want to understand the amount of damages you might get from breaching that contract. It's not something you want to take lightly. You want to be careful in all of this. Anytime you're talking about breaking a contract, you were talking about the potential of damages, potential of specific performance, as we've discussed today. And the damage claims can, get crazy, right? Sometimes the person who you damaged will suddenly pile on a bunch of incidental, consequential, other damages that they want to get paid for. And you could be looking at a big exposure, a lot more than what it would cost just to figure out a way to get it done. Even if that means hiring more people in your business, having some inconvenience, or paying a supplier more. So you really want to look at the overall situation that you're in. These contract disputes can be extremely complex. They are often very, very spec specific, which is why you want to sit down with a lawyer that knows your state, knows your law, understands your situation, and can really give you that specific advice. But it is just something you have to manage. Managing contracts, managing the performance of contracts, and managing the breach of contracts is part of doing business. And that's part of being an experienced business owner, really building your portfolio and making your business successful, is understanding how the contracts you sign impact you. And of course, get a good attorney to review your contracts, put the best possible provisions in there for you, because if you can fix some of these issues beforehand, if you have the right terms in your contracts, it may not be as ugly should litigation ensue. All right, folks, it's Shawn. Hope you're subscribed to the channel. You've rung the bell for notifications. Give us a like so other people can see this video as well. And join us for more videos soon. I'll be back. Join us in the comments if you have any thoughts on this, or if you have specific issues you might want us to cover in future videos. We read the comments, and we often learn a lot there, and we do tailor some of our content to what we learn in the comments. Catch you soon, folks.